I might have $5 in my pocket.
Well, no, I can't, then people see it. We need to like hide it in legislation. I can.
All right, good morning, everyone. I think we're going to get started. I believe a few of our members will join us in a few minutes. So this is the second committee meeting for the Select Committee on Special Education, and I continue to look forward to working with this group on an issue that is important to, I would say, every district in this state, across parties, which is why it's a priority issue. And so I look forward to hearing today, both for the members of the committee and for the public and everyone that's watching, some background on the sort of the context of special education in Connecticut, including the federal context, federal mandates, and where we are in Connecticut, and then some of the financial aspects from our colleagues in OLR and OFA. So that is going to be the majority of the time spent today, and then we'll open that up for questions. I just wanted to start, there were a couple of questions at the end of the last committee meeting, and I just wanted to address those. Those were about procedure of this committee. I did follow up and have a conversation with Chris Cordima at LCO, who's also here in case there are any further questions about that. And I apologize again, my voice has been gone for a week. This is not how I normally sound, but this whole week it has been. So first, as a Select Committee on Special Education, we have dual cognizance with the Education Committee. So we are going to refer our bills to Education. We can do that by their JF deadline. We can also refer bills directly to the floor, and then it can be referred to Education that way. We have the cognizance, our cognizance language includes having public hearings, which we're going to conduct, issuing reports, and originating and reporting bills like all other committees. We're going to work together with the chairs of education to make sure that our language gets into the bills that ultimately will go to them. This is a special priority, and so I think there's very much an intention for everyone to work together to make sure we're really addressing needs around special education as a sub topic of education itself. And then once we populate our bills, there was a question about the fiscal note. So we will have an OFA fiscal note, at least to estimate those costs. And I think those were all of the I wanted to just answer, and I'll then open up if there are any other questions, and Chris is here as well. But I wanted to emphasize again that this is a special priority, special education across chambers, across parties, across Connecticut. And so I really look forward to working together with this committee to make this work happen. Okay, so let me stop there because that was an answer to the other questions. And if there are other questions, while Chris is here, let me recognize Senator Kissel.
Thank you very much, Madam Chairman. And I'm really excited to be on this select committee. And I remember at the last meeting, Senator Austin said, even though a select committee, probably one of the most important committees this year, perhaps second only to judiciary. But I say that as a partisan judiciary committee member. My question is this: one of the interesting sort of conundrums that came up at the last meeting, and I think you clarified it, but I just want to make it crystal clear. It seemed odd to a lot of people, myself included, that our JF deadline was after the Education Committee's JF deadline. But the way you just explained it is, since we have such a heavy lift, especially with the select committee and this really intricate issue, is it structured this way such that if the time comes where the Education Committee's JF deadline has now come and gone, but we're still meeting, that then the methodology would be we can continue to function, put out bills, send them to the floor, and then they stay alive because then on the floor they can shoot them back to the Education Committee, and therefore the time hasn't been lost.
Exactly, Senator Kissel. That's exactly right. So we have the opportunity to either send it directly to the Education Committee by their JF deadline, or exactly as you said, because we have such a heavy lift. And I forgot to mention that we're starting to schedule our series of public hearings, really listening sessions. So let me call public listening sessions throughout Connecticut. So we will have one in Hartford. We're trying to hit the 4 corners of Connecticut. So we will have listening sessions, and we'll announce the ones that are finalized next week. But because we have that heavy lift, we have an extended JF deadline. So this way we can also directly send our bills, as you said, directly to the floor, and then it could be referred to education.
Thank you so much, Madam Chair. And that clarifies a lot of things. Thank you.
Thank you. Are there any other questions on this? Okay, wonderful. Thank you, Chris. I know you have another, I don't know where you are, but I know you have another meeting to go to, but thank you very much for being here. Okay, let me turn it over now to I'm looking forward to hearing from our speakers for today, for everyone in the committee to get the information on the context of special education in Connecticut, and then the federal context as well. So let's start with our representatives in the Office of Legislative Research. OLR going to give us a primer on Special Education Law 101. I appreciate it as a teacher. Thank you. And then we'll let you complete your entire presentation and then take questions at the end. Does that work?
Yes.
Perfect.
Yes, Madam Chair. Good morning, everyone. My name is John Moran. I'm a principal analyst with the Office of Legislative Research. And with me is Heather Poole, who's also a principal analyst at OLR. We're both assigned to the Education Committee and the Special Education Committee. This morning, we're going to walk through some highlights of state and federal special education law. And we'd like to just comment here that this presentation is in no way meant to be exhaustive, but it's our attempt to provide information on a number of the key issues of both federal and state law and how they interact. And we also like to mention that as nonpartisan staff, we're not here to advocate for or criticize the existing law, but we're just trying to explain it to the best of our ability. And as you were saying, we would like, if it's all right with you, we'd like you to, if it's possible, to hold questions till the end. We'd be happy to answer whatever questions you have. And now we just have one slide. It's just a brief overview. It's really pretty simple what our overview is here. It's just the federal law, the state law, and how the two interact, and then questions. So now I'm going to hand it over to Heather, and she's going to take it from here from the beginning of the presentation.
Good morning, everyone. And like Senator, I am also losing my voice. So please bear with me. I've done my best. I have my tea, but if I sound a little strange, that's why. It's not just you. So we wanted to start off by giving you just comparing the two laws a little bit that we're going to talk about today. So although there are several federal laws that provide protections to students with disabilities, some you may be familiar with is Section 504 of the Rehabilitation Act, or of course the Americans with Disabilities Act. The main federal law and the principal source of school districts' responsibilities for special education is the Federal Individuals with Disabilities Education Act, or the IDEA. The IDEA was initially enacted in 1975, and it's been reauthorized and amended several times since. It grants its main purpose is to grant students with disabilities the right to an appropriate public education, and it establishes requirements for identifying, evaluating, and educating eligible students. And as we do with many federal laws, Connecticut agrees to abide by the provisions in the IDEA by accepting the federal funds associated with it. There's also a state special education law that requires boards of education to identify students requiring special education and provide education to them. This law actually predates the federal one. It was established in 1967. But over time, it's been amended so that it now conforms to the IDEA and its requirements. So while federal law controls, both of these apply. And in some instances, the state has gone beyond exactly what federal law requires. So, of course, special education is a complex area of law, and at times it's somewhat nebulous, and it would be impossible for us to give you a detailed overview today. But it can be boiled down that the IDEA at least can be boiled down into 6 basic concepts, which we'll go over. The first and the most essential is the right to a free, appropriate public education, or FAPE. Adding to the complexity of the law, you'll find there are a lot of acronyms. Second is the right to an appropriate evaluation. And within this is the requirement that school districts locate students and evaluate them if they may require special education. Third is the individual education program. That's more commonly referred to as an IEP. This is the mechanism schools use to provide kids with disabilities tailored education and services that are tailored to them specifically. Fourth is the concept of the least restrictive environment, or LRE, which basically just means that students should be educated with their non-disabled peers as much as possible. Fifth is parental involvement, which is exactly what it sounds like. Parents have the right to participate in the decision-making for their students' education, and students actually do as well when they are old enough and it is appropriate for them to do so. Last, there are procedural safeguards built into the law. IDE is very specific about the processes and procedures that schools must follow, and this is basically to provide protections to students and their parents throughout the process, and we'll go over all of these in a little more detail. As I said, the very core principle of IDEA is FAPE, the free appropriate education. So IDEA gives students a right to FAPE, and all of its provisions are basically in service in protecting that right. So FAPE, it's free, free to families, but schools may charge fees if they charge them to all students and not just to students with disabilities. It is appropriate in that the services and instruction that children are provided are tailored specifically to them and their unique needs, and they're provided according to the IEP the school develops in concert with the parents. It's public, and then it's paid with public funds, and it includes K through 12 education that meets state standards. And while FAPE is the core principle of the act, the law doesn't actually provide a ton of specifics. So what constitutes FAPE is a commonly litigated question. So as a result, case law has further defined this a little bit, including that it must be designed for children to make progress in the general education curriculum. It must give students the chance to meet challenging goals, and it has to provide more than a minimum benefit, but it does not have to maximize a student's potential. Moving on to principle number 2, it's appropriate evaluation. So the IDEA requires schools to evaluate children to determine whether they qualify for special education, and also within that to determine what those educational needs will be if they qualify. It also places an affirmative duty on school districts known as child find to locate students who may qualify for special education, and to locate them and evaluate them. And usually they accomplish this through various outreach efforts. After evaluating a child, the school district must determine if the child is eligible. And under IDEA, you have to meet 3 criteria to be eligible for special education. It has to be all 3. So the first is having a qualified disability. The second is that the disability adversely affects educational performance. And lastly, that because of those 2 things, they require special education. I have listed the qualifying disabilities over to the right over here. I won't read them all to you, but you'll see that it ranges from very specific to more general. But it's not, and I just will emphasize, it's not enough to be medically diagnosed with these conditions. The condition also has to affect a child academically for them to qualify. Moving on to the IEP. Schools are required to develop an IEP for each qualifying child using the procedure laid out in federal law. IEPs are developed by an IEP team, which we in Connecticut call the Planning and Placement Team, or PPT. By law, that committee includes parents and a student, if it's appropriate, a general education teacher and a special education teacher, unless the student doesn't have one or the other, a representative from the school district who is knowledgeable in both the school district's resources and in special education requirements generally, an evaluation professional who can interpret the results of evaluations, and others who have special knowledge of the child. This could be like the child's paraprofessional if they have one. Sometimes it's advocates, sometimes it's other professionals that may be helpful. The IEP needs to contain a number of specific things, including goals for the child and the services the child will receive under the IEP. And there are not a ton of parameters in law specifically establishing what a school has to provide. But a 2017 Supreme Court case further specified that an IEP has to be reasonably calculated to allow a child to make progress given their specific circumstances. And just to drill down a little bit more, I wanted to go over what sorts of services they actually provide under an IEP. So of course, under an IEP, schools are providing special education, and that just means instruction services that are specifically designed for the specific child and their unique needs. This could include one-on-one class support, resource rooms, special classes, or extended school year. Students may also receive services called related services under the IDEA, and these are services that are necessary for a child to benefit from special education. These are things like physical, occupational, and speech therapy, transportation, psychological counseling, those sorts of things. But the key component here is that they have to be necessary for the child to benefit. It's not just enough for them to be beneficial, they have to be necessary. Of course, what is necessary is somewhat nebulous. You can see with transportation, if you can't get to a program, you probably can't benefit from it, but some of them are a little bit more nebulous. Lastly, IEPs can often include supplemental aids and services, which are typically provided in the general education classroom setting. These can include accommodations, which change how a student learns, the class material. So that could be like a preferred seat or extra test time is a common one. They could include modifications, which means the curriculum itself is adjusted to meet student needs. So you do the class pass fail, or you have, fewer questions on your homework or on a test. Children may also receive assistive technology if that helps them learn in the classroom, like digital recorders or text-to-speak technology. Moving on to principle number 4, it's least restrictive environment. And this is also sometimes known as the mainstreaming requirement, but essentially it just states that children with disabilities have to be educated with their non-disabled peers as much as possible. And to this end, federal law requires that if a child is placed outside the general education environment, that happens only if it's justified by the individual disability-related needs of that child, and that those needs can't be accommodated in general education classroom with supplementary supports. Unless an IEP requires another arrangement, this means that they are educated in the school they would attend if they did not have a disability. And if they must be educated elsewhere, the placement is as close as possible to the child's home. And over on the right here, I have a pyramid that illustrates the continuum of placement. Down at the bottom, which is the least restrictive placement and the most students, is the general education classroom. And you can see as you move up to more restrictive and the least number of students, you have, they're placed at home or the hospital or the residential school. And basically LRE states that you want to have the most students at the bottom of the pyramid as possible. I'll turn it over to Joan.
Thank you, Heather. So now we're going to go to principle number 5. You're almost to the end of the principles. Parent and student participation, which this is also mandated in the federal law and in Connecticut law, that it guarantees parents and guardians the right to be part of the decision-making process. Parents may request an evaluation from the school, which generally speaking must grant the request. And parental consent is required, generally speaking, for an evaluation of a kid for special ed services. There are times when a school district could do an evaluation of a child without parent request, but parent would have to say no, and then there's a separate process they could do to pursue that if the school really felt it was necessary. But generally, parental consent is required. And parents and the student where appropriate are part of the PPT. So that's a big part of the law, and that the PPT meeting is where you sit and decide what are the services are going to be for that student, and to have the parents be part of that is crucial to parent involvement. Now, principle number 6, procedural safeguards. So again, with the federal law and with our state law, there are a number of safeguards to protect the child's access to FAPE. So the parents, there's all kinds of notification requirements about when certain things are going to happen for the parents. Parents have the right to request an independent evaluation, which would be at the cost of the school would have to pay for it. This would be in addition to whatever the initial evaluation was. And there's a process where the school could object to that, but in general, the parents have a right to an independent evaluation. And the parents have right to the access of all the educational records of that, of their child. And the last one, kind of a big one, dispute resolution. Most people are probably familiar with the due process hearings, which is a pretty legal process where a hearing officer hears testimony from both sides of the family usually and the school district if there's a dispute over what should be provided to the child, and then the hearing officer can make a decision. And this involves, it could be testimony at the hearing. It's a pretty legalistic process, and those decisions are available on SDE's webpage. And so that's a more formal, like I say, legalistic process. There's another process, and that's usually focusing on the needs of an individual child. It's a family pursuing something for their child usually. And there's also just a general complaint process. You can complain to SDE's special ed division. And I think that's more, I think if it's a generic complaint, like we think school district X is doing a poor job on this area versus versus the hearings, which are more about individual student needs. So now we're going to try to point out some of the places where in Connecticut law, where over the years, the legislature has added some extra details that either are just further conforming with federal law or are state-specific things that the legislature added that are on top of federal law. So here's just 4 details that are just, again, really in conforming with the federal law. Districts must follow the federal and state procedures for identifying children. Districts must give SDE a whole bunch of data related to eligible children, their race, ethnicity, and their disability category. That's because the feds want all that information. And the parents must receive a written notice before the districts propose a change in an IEP or refuse to follow through on a change in an IEP. Districts must also comply with due process hearing procedures when the parents request a hearing. So when the parent triggers the action by requesting the hearing, that puts the onus on SDE to follow certain procedures. So now we thought we would mention a few things because this comes up in the legislature a lot. What are things that the legislature has added that are in addition to the federal law? So some people could argue that some of these additions are certainly in the spirit of the federal law, but they're not literally required by the detail of the federal law. This first one was just a few years ago where the legislature enacted a law requiring every school board to appoint a district-wide transition services coordinator. And the law also says that coordinator must get training from SDE. The next one related to transition services is that for students age 14 and older, an IEP must include transition service needs for that child, trying to anticipate when the child ages out of the K-12 system. Under federal law, you have to do that by age 16. So Connecticut moved it up 2 years earlier. For PPT meetings, the districts must offer parents and guardians a meeting before the PPT meeting to discuss the process and review any assessments. Again, this is something that Connecticut legislature did, trying to make the process more family friendly or accessible to the families, because there's a lot of technical terms and maybe a lot of things they're not familiar with. So the idea is you'd review some of the process and the assessments beforehand. Also, school boards may not take any adverse action against an employee who makes a special ed recommendation. So let's say a paraprofessional or someone like that in a PPT meeting, if they recommend something for that student, the school district couldn't somehow retaliate against them. On the due process one, in Connecticut, the school boards have the burden of proof in a due process hearing, where if not for that Connecticut policy, the burden of proof would fall on who's ever moving the action, who's ever instigating the action. Gifted and talented, we require that districts have a policy for identifying gifted and talented students, and that's a separate additional thing we do. And the last one we have on our list is private providers, that the districts must enter into contracts with private special ed providers in order to get reimbursed from the excess cost grant program. There had been this was only done about, 4 or 5 years ago. There had been some districts using private providers and they didn't have a contract. And I think this was at the instigation of the auditors of public accounts. They thought, if you're going to be paying these people, you should have a formal contract so you know what they're doing for you. But that's just to highlight some of that. Now, we also thought, this question comes up a lot, special education responsibilities for choice programs. So this is just to highlight when a student is in a choice program, a magnet school, a charter school, open choice, VOAG, or the technical high school system, when they're at that school is responsible for carrying out and executing the services in the IEP. But generally, the sending district is still on the hook for paying certain costs, even though that kid is not in that district. So, but some things are subtracted from that cost. Like for magnet schools, the district will pay a cost, but you'd subtract from that cost any magnet school grant that the magnet school received or any tuition that they got. So you're not double counting those numbers. And the same thing with the other programs like VOAG. There's also tuition involved in VOAG. You would subtract that from the cost that the sending district would pay. So the one that stands out different here is that the technical high school system, which is totally paid for by the state, it's a state system. When that student goes to the tech high school system, the tech high school system pays the costs. So at the end, we just thought we'd throw in this quote from Mooney's Guide to Connecticut School Law, that which is a very good reference for a lot of these things that we put together in our PowerPoint. They're just saying that once you understand the framework of the law, the big pieces of the law, that's easy enough to understand. But then the challenge that all these districts face is to figure out what exactly the specific services are needed to meet the unique needs of that individual child. And there's like around 86 or 87,000 kids that are considered special ed in Connecticut. So that's a lot of IEPs and a lot of plans that have to be determined precisely for the unique needs of each child. So that's our presentation, and we would be happy to answer any questions we can before OFA comes up and does their part.
Thank you so much for that presentation with a lot of useful information. So I'm going to open it up now for questions, and I want to recognize Senator Austin. First question.
Thank you very much for that. I appreciate it. And generally I require people to just do 2 questions in the Appropriations Committee. So in interest of not irritating people that might have that happen, I have 2 original questions. One is on the key principle number 2, going to the first statement that says school district has an affirmative duty to locate and evaluate children who may require special education. What is the consequence if that's not followed? Is there a statutory consequence to that? And anecdotally, I would point out that many children are not identified, whether they become later incarcerated and find out that they have been, that they had this special education need, or they're just somebody who travels right on the edge and the school doesn't do it. We all heard the horrible case in Hartford where the young lady was not receiving the requirement of special education services. Is there a consequence for the school district? I've put in bills on this before, so that's why I'm really trying to figure out what is the consequence to a school district that decides that they're not going to do this.
I don't know if there's a specific consequence, but I know in the
Guys, you could
past,
speak into the mic. I
I'm
think
sorry.
they're having trouble
I-
hearing you.
sorry
Thank you.
about that. I don't know if there's a specific consequence, but there have been cases in Connecticut where parents have brought complaints to the feds or filed like a federal lawsuit. So you can sort of go outside the sort of the standard things I would say that we just presented. I seem to recall there was a lawsuit against, I want to say Bridgeport, maybe like 5 or 6 or 8 years ago, where they were saying that Bridgeport was like systematically not performing this duty. I mean, we could try to find out how some of those things were resolved.
That would be helpful, but I also think that that's somebody whose parent has the ability to do so, or the knowledge on how to do that. So if you have a child that is not performing to a certain level, and the parent doesn't know how to get through this system, and I've been through this system, it's very complicated and it's very hard. So I just want to, if we can find out what the action may be, that is something that I would find interesting. And my second question is on page, it's the special education responsibilities choice schools. And I happened to be in a meeting where you provided us some information on the CTEC law that changed special education from the sending district to CTEC itself. And nowhere in that law does it require the sending school to have an affirmative meeting with CTEC. It says that there'll be a meeting at the sending school, but it doesn't say there'll be a meeting at the sending school in conjunction with the CTEC schools to see where those children are. I know that in high school, you're not really a child anymore, I guess, but I kind of think you still are. So I have a hard time with this one because it resulted in $18 million in costs. You would think those $18 million were actually achieved in savings were achieved by local school districts, but I get the sense that that did not happen. So I'd like to sort of understand how did this, I don't care how it happened. Let me just say, it happened. So, but I think that we really have to look at this because our CTECs are now incurring costs that they never anticipated having to deal with. And usually those costs are borne by the sending school. And in this case, it's borne by the technical schools, and they have had to contract this out. They have had to bring on additional staff. They had to start the IEP PPT process all over again instead of using the original materials that were held by the school, the sending school. So I think that it's just something that, and I read what you sent me and I just don't see where there is that connection between the sending school and CTECs on what they were receiving for services, where those services were held, and how they happened. So I'd like to find out, did the sending school achieve savings? And does the technical school have the capacity or even the understanding on how to do IEPs, PPTs, et cetera? So that's something I'd like to add to our list of data to try to collect. And in other states, do CTECs, do technical schools handle this responsibility, or the sending school? Thank you, Madam Chair.
Thank you, Senator Austin. And let me recognize Representative Corpus and then Representative Zepkis.
Thank you for your presentation. 2 points of clarification that stem from our meeting last week. The first is on principle number 2. Children who have, for example, ADD or ADHD and are subject to a 504 program, but don't have anything else that would rise to the level of an IEP. When we talk about those children, they are not included in either the dollars or the programmatic attributes of special education, correct?
I think that's correct. I think they're not counted as what we would call special ed.
Okay. Because I think there, at least in my district, there's a misconception when we talk about special ed and special ed costs increasing. It's because of the increase in diagnoses of ADD, et cetera, absent anything else. But the truth of the matter is those are not included in special ed. Absent
Well,
anything
there
else.
there is a chance that a child with ADHD could qualify for special education.
If they
uh,
also have an IEP, if they have something else which rises
Yeah,
to the level of an IEP.
ADHD falls under other health impairment.
Yep.
It really depends on the specifics of the child. I think sometimes ADHD, if it's severe, can be sufficiently impairing that they would require some form
Okay.
of special education, or their kids it really depends on what their educational needs are, whether they qualify. The diagnosis could really go either way, depending on how exactly it affects them and what they need as a result.
Okay. And the second question is similar. Children who are English language learners who don't otherwise have a qualifying disability and therefore don't have an IEP are also not included when we say special education, either for budgetary or
No,
programmatic purposes.
No, I think that's a separate line.
Okay, thank you.
Representative Zepkis.
Thank you, Madam Chair. My first question is kind of, I don't know that it was answered, but it was regarding the tech high schools. So I won't get into that as to why, but at some point I would be interested to know how that happened. And then my second question is, why is gifted and talented included in here?
That's been in the law a long time. I'm not entirely sure why. I think, and this is just going back to some of the, I want to say older terminology. Sometimes they use the term exceptional child. And I don't know if that was meant to be some kind of umbrella that would exceptional, meaning kids who need extra help. And that exceptional also meant that kids were excelling beyond other kids. But I'm not really sure of the history of that, why gifted and talented is just embedded in our special ed law.
Okay.
That's where you find it in the statute, literally.
I was asking because at our school district, we had a gifted and talented program that was different from special ed. And so I know at one point the funding got cut and we had to do, now I think they're working on it. But I was curious, is that have to do with something with the funding? Does gifted and talented get part of that funding?
An identification requirement, and then I think the districts are supposed to refer the family to other resources if the district, let's say the district doesn't have a gifted and talented program, which a lot of them don't now. So then they were supposed to refer the family to resources that could be helpful. It's just like a referral or informational duty on the school district. But again, that's like we're mentioning, that's not part of the federal law. That's something we
Right.
have in our law.
Thank you. And I'm not going to harp on it, but I have one kid that I would say is gifted and talented, and the other kid that did have an IEP, two separate completely different learning abilities. And so for the one that's gifted and talented, are you saying the school would have to provide something for, say, my child?
I think
the
they just have to
special ed.
provide some information, like, oh, here are the resources in your area. That was the way I mean, it's actually in the statutes. We could find that for you. They'll first evaluate them, and then they would have to, if you're determined to be gifted and talented, however they exactly define that, then they just would refer you to resources. This is assuming the district doesn't have a special program for it.
Unlike special ed, how
Yeah.
they would refer you out to an
Yeah.
outplacement or whatever.
Yeah.
Okay, thank you.
Okay.
Representative Malinsky.
Thank you, Madam Chair. My questions come around, the presentation, thank you very much, is very nice and concise, but anecdotally, for about 12 years, I've been hearing from parents about how adversarial the process is of requesting an IEP, PPT, and oftentimes the fact that they're made to be felt like they're being isolated, they're the only ones with that type of a problem. It's actually, they're very, very touching stories. But my question is, in the process, if an IEP is requested by the parents, can it be denied? And if it is denied, what is the remedy that the family can seek? Because historically, what I've observed is that parents end up in some sort of litigious situation where they are totally adversarial with the school district, and to me, spending $1 million of district money on litigation that should have been put into special education. $1 million pays for a half a dozen professional interventionists. So I just where would a parent go aside from a civil rights attorney to air a grievance?
If I want to restate your question, just to make sure we think we understand. So if you requested an evaluation of your child for a certain thing, you think my child might have this, and you want your child to be evaluated for that specific thing, and they're saying, no, we don't think that's the problem, and they're denying you an evaluation. Is that where you're seeing the problem that you're describing right now? Or I'm sorry, maybe I was misunderstanding.
No, that's okay. I have a hard time expressing it because no two of these cases, play out identically. But there are a fair number of parents that I have met over my years that come to the point where they insist that they're being denied an IEP, that the clinical recommendations of their child and their child's clinician are not necessarily considered as part of the evaluation, and it becomes a conflict situation, and they don't end well.
So do you mean like there's a service that they think should be included in their IEP by virtue of what the parents have done for their child, and the district is saying, no, that service should not be added to your IEP?
Yes.
Okay.
Or they don't have one
Okay.
entirely. One, or they were never evaluated in the
I'm
first
sorry.
place. It sounds like it's also that students were evaluated and told they don't need an IEP, or that weren't about. I think we understand they don't have an IEP, or they're being
So,
denied.
yeah, there's a few different iterations here, but there's a few other steps in law we didn't touch on today. Like there's a whole mediation process before you go to the due process hearing, which is again more, I want to say, adversarial and confrontational. There is a mediation process that is in the law, and the state SD is supposed to help get the two parties together and discuss things. And if the problem here, it sounds like it could be either the problem of, I think my kid has this and you are not evaluating my kid for this particular thing, or I think we agree on what my child has, but we're disagreeing on what kind of services that child needs for their situation. Those could either be things that could be the subject of either mediation or due process hearing. So due process hearing, I think you do get a lawyer for that, but the mediation, you don't have to get a lawyer. And I think one of the bills from a few years ago, they were trying to, one of our 5001s, and excuse me if I don't remember which 5001 it was, but was requiring SDE to like beef up their mediation processes. And I heard from some caucus staff just recently that SD just finally hired that mediator, that person to be in charge of mediation coordination in the state. So like the idea is to like push more of that to have fewer people have to go to the due process, which is more confrontational. So I'm not sure if that helps you a little bit. I feel like it doesn't.
It probably requires some further conversation that we can.
I mean, I think I've heard of instances where sometimes the district, maybe it's almost like a negotiation with the family. The district might agree to do something, to do an evaluation on whether your kid is dyslexic or something, but maybe that district doesn't feel like they know how to handle dyslexia, but they might at least pay for doing the diagnosis. And then you see where you go from there. How bad is it? How much help does the kid need? So, I mean, a lot of times these things are they're almost like individual negotiations that people work out. And I'm not sure if that really helps you either, but yeah, we can talk more if we want to like
So
drill down to us.
So is there does SDE play a function in that mitigation process if there's disagreement?
I think they do, yeah.
Do the parents know how to access that?
Well, we should also mention this. They have a Parent's Guide to Special Education on SDE's webpage, which is like 100-page document. It's got a lot of good information in it, and it explains these different steps that families can go through. And then there's also, I know I was gonna say, there's also there's like a parent advisory council also. So there are some bodies out there that you can reach out to, but again, for the average parent, you don't automatically know this information. If your child has a problem, usually you might learn about it through other parents or maybe a teacher at the school, or you know what I mean? You have to like reach out. There's SEEK, there's different organizations in the state to help families out. So.
Okay. I mean, over the years, I have spoken with parents, and I've spoken with paraeducators that have all been, despite the fact that we have it, in writing that that it's a collaborative process. I have been approached by more than one para that was, and again, this is a personal matter between parties, so I have no idea what actually happened, but stories of intimidation, stories of termination, and by parents that have spoken about consequences to the way their child is treated within a school building, and retribution from a denial gone bad. So and I mean, I could present people to speak with the committee, but it's a topic of conversation that concerns me, because for every family that has a terrible experience in trying to do what's best for their child. Again, I believe that litigation is a complete and utter waste of money. We should not be making attorneys wealthy for the services that so clearly are, spelled out in state and federal statutes. So, and I'm not certain there's an answer for any of that other than just the understanding of the chairs and the committee about the need for uh, uh, a remedy for situations gone bad. So I'm going to be quiet because I think
Well,
that.
let me just add,
we have
Representative
folks that are-
Alinsky. Yeah, I think so what you're saying, I think through these public listening sessions, hopefully more stories will also come out. So we'll be able to paint a picture for this committee. We'll be able to get a better sense of some of these sort of specific stories and start looking at the overall patterns. So thank you for that.
Thank you, Madam Chair.
And then I did have a question just to follow up on that. And there are a couple of questions from fellow representatives on the due process structure. So is Connecticut, I understand, is one of the few states that has the burden of proof on the school boards. And what's the rationale
Yes.
for the states that do that, and the rationale for and how many other states sort of follow that same structure?
I think we're an outlier, though. I don't think there's a lot of other states that have that. I think the other states I think there's a Supreme Court decision that said, because I think IDEA was silent on this, and I think, and so there's a Supreme Court decision from a long time ago that just basically says whatever party is is pursuing the action, initiating the action, the burden of proof is on that party. And I think the rationale in Connecticut was it's been this way since before I was on the committee, so it's been this way for a long time. The rationale was that the parents usually have less resources, and that's why it's a state regulation in Connecticut. It's not a statute. That's why the burden of proof is on the school district. So because the thinking was just your average parent doesn't have the same resources that the school district does. In the past, there's been bills to undo that, and they haven't gone very far in the past, let's say 10 years or so.
Thank you. And then Representative Johnson.
Thank you so much, Madam Chair, and thank you for this great presentation. I have a couple of questions. First, and the principal one, at what point, I see that it says preschool, but I know that birth to 3 and a continuum of care from birth to 3 to preschool to kindergarten to first grade tends to create more success and addresses some of the diagnosed perhaps or looked at possibilities for the need for special education. I just wondered at what point in terms of your presentation here today, would that be a requirement, or how do we deal with the fact that there's a continuum? For example, in Wyndham, we created a birth to 3 preschool, kindergarten area to first grade for that whole continuum, and other towns have done this. Some towns don't have that capacity, and they have a birth to 3, something to do with the preschool, then the kindergarten, and they're all different. And so sometimes what happens is the initial way of addressing the child's needs gets changed and maybe impedes the actual development, that if there was continuity, there would be a better outcome. So by the time the child gets to first grade, much more a functional capacity.
So I just want to make sure I understand your question. So you're wondering about how, and we do have, there is the child find obligation is on everyone. So the duty is there, but you're saying sometimes we just have different programs in different towns, and therefore not everyone has a smooth transition. I would say that's probably true. I'm not sure what is your question
But
like.
how to address that, because so that while we're looking at how to deal with special needs students in this committee, how do we take a look at maybe making better continuity for our students from birth to 3 all the way through? And I think birth to 3 might be ignored some when it could be a cost savings all the way down the line if we're able to create that transition from each as the child develops into the first grade, that they would be able to have the continuity and the care. And I'm not sure where that fits in with what we have now in existing statutes, and where that might be a way to address that kind of an issue for the students to be able to move forward with a continuity of care, or just getting that those changes addressed through the system. And this actually comes from when I served on the task force to address developmentally disabled students a couple of years back, and we did extend the time period, which will lead to my next my next question. But first, I just wondered if there's a way for us to articulate language in statute to make sure that there's continuity of care and that these things are addressed so that
We would have to look to see if there are anything that exists. I'm actually I can't remember what letters, but the IDEA has several parts, and one of them I believe is birth to three. So I don't know to what extent federal law actually connects the two. I'd have to look into that, but we certainly could do that.
excellent. So yeah, I just want to make sure that it's really clear in what we're doing here so that we have that conversation and make sure that the continuum of care starts right away. And then the other question that I have is at the other end of the age groups, starting in around the ages from around 15 or so to, and now we have students with developmental disabilities or behavioral health issues. So starting around 15 or so is when it's fairly well known that people that have a serious mental illness develop schizophrenia, develop maybe a severe bipolar disorder. If those things are noticed, sometimes they may be thought of as, just a very extreme adolescent behavior as opposed to a mental health problem, and maybe ignored and treated as an adolescent behavior or adolescent that's not behaving properly. And in that circumstance, is there anything that we're doing to address that type of analysis?
Yeah, I mean, it would just, I think what you're describing would hopefully be captured in just any ongoing IEP process for the child as they go through their high school years. Depending on what, the symptoms or what behaviors are occurring. And I would assume they would be noticed by the educators and the parents, and they would try to address it. Is that
Yeah, I would also say, and please I'm speaking off the cuff here a little bit, and this is a new area of law for me, but I do remember reading a requirement that if there's a child who has continuing behavioral problems, that they are supposed to be referred for evaluation. I can't remember if that was just SDE guidance or if it's actually somewhere in law, but if you have a child with repeated behavioral problems, you're supposed to consider the possibility that something more significant is causing that rather than just, growing up.
And so is there some standard for analyzing that? Because I think that what happens is a lot of times the schools resist in some circumstances the idea that they need to go through this process, particularly if there'd been nothing wrong or noticed about the student before that. And then
it should be, yeah, if there's a new problem that's surfacing and the parent brought it to the attention of the school, and it should be addressed really. I mean, at least on paper, this should be addressed at a PPT meeting. The parent can request a PPT meeting at any time. Typically they're annually, but if like a crisis came up or something was going on, you could request to have one sooner. And if you felt like there was other services that needed to be added.
Mhm.
So that is available. But again, it's sometimes people may not be fully aware of what their rights are. They may not feel the district is cooperating, or any number of things might get in the way of that. But at least on paper, you should be able to adjust as you go.
Mhm. And finally, state of Maryland has a program now that reviews all students in the school systems to make sure that there is no behavioral changes or behavioral needs or educational needs based on the listing that you have here in the principle 2 or wherever you're listed. Yeah, it's principle. Yeah, key principle 2. And they go through this diagnostic service every year. And I, didn't know if we have anything that we could utilize to maybe take a look at how Maryland is doing that and maybe see how that would work here in Connecticut. Thank you so much. Thank you, Madam Chair.
Thank you. And I think Representative Wieland, give you the.
Thank you, Madam Chair. Good morning. Thank you for the information you've shared today. I just have two quick questions. One is, do you know how much notice is provided to parents if a proposed change in an IEP happens or is proposed?
I think we do, I think our law is specific about it. This will test how fast Heather can find this on her phone.
I can ask the second one and if that helps.
Just looked at it.
But there is a certain number of days stated in the law, so.
And that's uniform across the entire state, not district by
Yes,
district?
Yeah, I
Okay.
think it might be like 5 business days or something like that, but hopefully we can find it in a moment. And I think that was something that we add in state law that isn't specific to federal law. Federal law says you must give them advance notice, and we said how many days advance notice.
Okay. Do you want me to ask my second
Yeah,
question?
I would
Okay,
say go
sure.
ahead.
Regarding the private provider contracts, do you know if they are, if this is also across uniform across the state, and is this done for individual students or per year by district, a blanket thing? Do you know how those are structured?
I don't know off the top of my head, but I think SDE was trying to have some kind of trying to bring some kind of uniformity to that situation. And they have a bill this year. This is sort of touches on what you're talking about, where they're gonna take a step towards having at least more reporting on the cost, the rates they're charging for different things, because districts find the rates increase from year to year. But I don't know that there's any requirement for like a uniform contract or for a particular type of services.
Okay, thank you.
I found it.
Uh,
It must be provided after a school district makes a decision and 10 school days before the action is taken on that decision, unless both parties agree to waive this notice.
Okay. So if both parties, the school and the family, agree that changes can be made without notification beforehand, then they can do it willy-nilly? Well, not willy-nilly.
Yeah, I'm not sure if
but-
it's beforehand, or it also seems like if they both agree to they can just be like, it's fine, just do it
Okay.
now.
I'm sure I can see that, parents and providers saying, we're going to give these things a try if that's okay. And we don't have to get a uniform or a proper notification or official notification. Thank you so much. And I just want to, as we are all talking about special education, just make sure that I'm saying for myself, because I can't speak for anyone else, but I'm sure it's a common theme, how much we appreciate our special education teachers. And these questions are not indicative of us questioning their ability or their qualifications. Thank you, Madam Chair.
Absolutely. Thank you for adding that. Are there any other questions on this? We have another presentation after this, so I'm just aware of that. I don't see any questions online.
Yes.
Oh, there
I
are
have
questions online?
Yep.
Yes. Oh, Representative Nuccio.
Thank
Go
you. So one of the questions we looked at different states and how things were being handled here. Is there any indication in any of the research that you have in regard to how other states are funding special ed needs outside of the money that they get from the federal government for the IDEA grant?
That's going to come up in the next presentation. Yeah. So
Okay.
maybe you can start with the next presentation, perhaps, unless you have an answer, but we can leave it to OFA.
Okay,
Yeah, whatever preliminary, but I think that will come up again too.
Okay. Thank you.
All right, and Representative Nuccio, we'll start with your question for OFA at the end of their presentation. Wonderful. Thank you so much for that. And it was very informative, very helpful, and for answering all of our questions. Appreciate it. Great. And I will have our thank you office, our representatives from the Office of Fiscal Analysis come up to tell us a little bit about funding as it relates to special education. Thank you so much.
Okay, thank you for having us today. I'm Candace Fair. I'm the OFA analyst for the Department of Education. And today I'll be giving a brief overview of special education funding in Connecticut. So the presentation will flow something like this. We'll talk about the big picture first and the students and the spending that are involved in special education. Then we'll dive into the ECS and excess cost grant and their role in funding special education. And we'll finish up by talking a little bit about federal funding and maintenance of effort requirements. So of all the students that are counted in the ECS grant, about 87,000 of them are identified as special education. And identification has been rising slightly over time. In fiscal year 14, about 12.4% of students were identified as special ed. And in fiscal year 23, about 16.7%. So that's a little over a 4% increase over 10 years. This chart shows the breakdown of local, state, and federal special education funding. In fiscal year 23, the total cost of funding special ed was about $2.6 billion. As you can see in the chart, the local funding is the biggest share. Local and regional school districts provide the majority of funding for special ed. In this same year, they spent about $1.7 billion. And then the next biggest share is the state share at about $680 million. And the federal government had the smallest share at $1.7 billion. So you might be thinking that that $680 million that the state spent on special ed might sound like a big number to some of you. That's because a portion of the ECS grant is considered funding for special education for maintenance of effort requirements that we'll talk a little bit about later. This comes from historical changes to the ECS grant. In fiscal year 96, about $250 million of a different special education grant was rolled into ECS funding. So because of that, SDE estimates every year about how much money is spent on special education from the ECS grant. And in fiscal year 23, they estimated about 23% of ECS funding was spent on special ed. So this chart shows total payments over time. As you can see in recent years, the total payments that towns received, this is the money they actually received, not what they were eligible for. In recent years, this amount has increased, and that's because the appropriation for excess cost also increased in those years. There were a handful of policy changes, and the excess cost grant was altered a little bit in those years, and so the appropriation increased along with those changes. And in fiscal year 24 and 25, the appropriation was a little bit over $181 million for excess cost. And the excess cost grant is a current year reimbursement. So school districts get reimbursed by SDE for special education costs that are more than 4.5 times the school district's net current expenditures per pupil. And that net current expenditures per pupil number is the average cost of educating a student in a district. So if a district's NCEP is about $10,000, they would have to spend 4.5 times the $10,000, which would be $45,000 in this case, on a single student to qualify for the grant. And then any amount above the $45,000 is what is eligible for reimbursement. And this number changes based on the district. In fiscal year 24, there were a little over 4,000 students, 4,351 students who had eligible excess cost expenses. That's about 5% of all special education students and less than 1% of all public school students. Like I mentioned briefly earlier, the excess cost grant is a current year reimbursement. Which means we don't know exactly how much it's going to cost year to year, and that makes it difficult to budget for and difficult to predict how much it will cost. And because of that, the appropriation is often insufficient to fully fund the excess cost grant. So this chart is showing the appropriation and the total uncapped entitlement that districts were eligible to receive reimbursement for. As you can see, the uncapped entitlement, that orange line, is consistently higher than the appropriation. And in recent years, the difference between the two lines has grown significantly. In fiscal year 24, the excess cost uncapped entitlement increased 25% over fiscal year 23 numbers, which was larger than anybody expected and has happened in the past. And then our estimates for fiscal year 25, those numbers won't be finalized until March or later when districts submit all of their reimbursements. But as of the estimate right now, the cost is about 11% higher than fiscal year 24. So because the appropriation and the full funding amount are different, reimbursement tiers were introduced to allocate the money across districts, the available appropriation across districts. And towns are ranked in descending order according to their adjusted equalized net grand list per capita. And the higher ranked towns are more wealthy than lower ranked towns. And so it distributes the money based on town property wealth and income. And another interesting thing about the tiers is that they change year to year. The reimbursement rate changes year to year, depending on how much the appropriation is and how much the total cost of funding the grant would be. We want to ensure that the total excess cost appropriation is used without leaving a deficiency in the account. And so these are the reimbursement rates that were used for fiscal year 24. The least wealthy towns got 71.4% of their eligible excess cost reimbursed, and the middle tier got 69.1% reimbursed, and the most wealthy tier got 66.7% reimbursed. So moving on to federal funding, we'll just touch briefly on this. Federal support for special education funding is provided through the Individuals with Disabilities Education Act. And their target is to fund 40% of the national average per pupil expenditures for each student with disabilities. And the federal government has never fully met this target. And perhaps one of the most important aspects of the IDEA is the maintenance of effort requirement. And the bottom line is that in most cases, state and local funding can't be reduced. One example is when an extremely high needs student moves out of district, then it can be reduced if needed. And these requirements exist at state and local levels, and therefore both budgeting and spending of special ed. And there's multiple ways to calculate the requirements, so it can be adjusted based on what is needed at the time. And that concludes the presentation. We're happy to take questions now, or if you have any come up in the future, this is our contact information at OFA.
Thank you so much for that. There's a list of speakers, so I'm going to go down. And I promised Representative Nuzzio the first question. So if you wanted to jump in.
Thank you. I appreciate that. So thank you for this presentation. A lot of it I kind of learned through my own gathering. Couple of things that were on there that I think are questionable is the excess cost. You know, we have the tier program, but if there aren't enough appropriations, we're not even paying at the tiered level, and that tiered level isn't 100% of the cost. So in that case, say it's the 70%, and the excess of the 4.5 is, I'm just picking a round number, it's $10,000. So if the state paid 70%, that meant that other 3,000 then has to be picked up by the town on top of the 4.5%. Is that correct?
Yes, that is correct.
Okay, so, all right, I just want to get that out there because I think people think that, oh, after the 4.5, the state pays for everything, and they don't. In a lot of cases, they're not even paying, you know, what the excess cost percentage is. The second question that I had, which is what I asked in the past, I'm really concerned, or interested, I guess you could say, as I would like to understand how other states handle their special ed costs, because I think all of us could honestly say we know that this is, the Board of Ed budgets are the main driver of property taxes. And a big piece of the Board of Ed budget is the special ed costs. And when you talk to superintendents, or you talk to boards of ed, they're just saying how their hands are tied and an outplacement of $200,000. There's nothing that they can do. So I'm really curious as to what other states do in relation to special ed spending. I personally am not in favor of the 4.5 number. I think, it really, really, really hurts our small towns disproportionately than it does anybody else. So I have a lot of concerns around that, and I'd like to just understand, how does Connecticut look in the scheme of things?
Thank you for your question. We need to look into that and get back to you. We don't have enough information to answer it well at this point. We know that states do a wide variety of grants for special ed costs, but we can't talk knowledgeably at it at this point. So we'll look into it and get back to you.
Okay, I appreciate that. I think if we had that information, that's probably key to really starting the conversation here about funding, is really just understanding what our options are and what we could do to fix things. So thank you for that information. I really look forward to getting it.
Thank you so much. And let me just follow up on that. And I know there are other questions. With the tiered system, within those tiers, is there any, I know you said you account for least wealthy to most wealthy town, but there are some school districts within the same tier that may be spending more or less very intentionally. Is there any accounting for that? Because then the school districts that are within the same tier that are spending more are in fact, in a way, not getting as much back or being penalized, however you want to sort of frame it, as others in that same tier that are spending less and sometimes maybe intentionally.
There's no adjustment for that sort of differential between spending amongst towns. It just depends on what their needs are for their students. And
Okay, thank you. And my co-chair has the next question, Representative Khan.
Thank you. I have a couple of things. One, I just wanted to point out, just for committee's sake, on Wednesday, our meeting on Wednesday, we're going to be meeting with the task force on special education. I don't know that some of their report does go into how special ed is funded in other states. So hopefully we get some information there. And then if we feel like we still need more, then we can look into that. But I did want to just prep everyone for Wednesday. So come with your questions for other states. All right. So just going to the second, technically the second slide, the one where you talked about the percentages from 2014 to 2023. Do you have the national numbers by any chance?
I don't have them on hand, but I can get them to you.
Okay. Well, so I did a quick Google because
Okay.
I just wanted to know.
Great.
So just for the sake of the committee, just because I'm interested. So as per the National Center for Education Statistics, the number from the same years rose nationally from 13 to 15%. So kind of ballpark. And then the range right now currently is 12 to 21% across states. So we're at 16.7, which puts us in the middle. So it's not just this alone. Kind of looks like, well, what's going on in Connecticut? But I think there's somewhat of a national trend of an uptick. Why that is, that's a whole nother question. I didn't have as much time during the committee meeting to do that, but I just wanted to point that out for our committee's sake. And then one other question, the chart that we had with both lines, the blue and the orange line, we could just go to that. Yep. So the blue line represents what we have paid out to districts, correct? And the orange line are the asks that have come in from districts. Yes? Okay. So just if I'm looking at it correctly, roughly it looks like what we paid out in 2024 was the ask by districts in 2016. Am I reading that correct?
Yes, that looks correct to me.
Okay. So, because again, this chart also, like, all of a sudden, especially that orange line, the asks, like the last few years have definitely gone up. And that'd be interesting to figure out what's going on there. But I think if I'm looking at it across the 10-year span, there seemed to be an increase in ask every year. There was definitely a drop after 2020. And then after that, continued to go up. But I just wanted to point that figure out, if anyone else didn't notice, that what we paid out in 2024 was the ask back in 2016. If I'm reading that correct. All right, I have no other questions. Thank you.
Thank you. And Senator Alston, you have the next question.
Thank you. On the page that talks about the number of special education students, and it said that 87,000 of the students counted in ECS. Can we get the number of the total children so we can actually compare those two numbers? The number of total children and the number of ECS, the number of total students, the number of special education students, and the number of excess cost students on a trajectory so that we can look at that. I don't need that answer right now. I would also point out that to Representative Khan's pointing out in 2016, we were paying out today, but we also paid out what the requests were in 2022, more than the requests in 2022, more than what they were in 21 or 20. So we have attempted to keep what we were attempting to do there, having been in on those conversations, was to get 100% of excess cost payments. And so, yes, it goes back to 2016, but you track it all the way across, and many years we were right there. I have a question, a real question on the federal funding, because a lot of people just avoid the federal funding. They say we should take care of this on the state side, but it says IDEA required 40% of national average per pupil expenditures for each student with disabilities. And right now, by my calculations, we are between 6 and 8% of federal IDEA. Now, the numbers that we're counting here on special education funding, does that incorporate Title I, Title II, Title III, and IDEA, or is it just IDEA?
The numbers for the federal spending in the sources of special ed spending chart is just for IDEA, I believe, and not inclusive of the other
So
titles.
I'm curious about that, because if we could get federal funding in total for Title I, in total for the state of Connecticut, in Title II, in total for Title III, and in total for IDEA. So, and what those grants are for. What is Title I for? What is Title II for? You know, that to give us that comparison there, so that is a comparison. And do you have any idea why the state does not pay for special education for Unified School District 1?
No. You're referring to the corrections?
I'm referring to corrections when we're
Yeah.
not addressing the issue of children being identified at earlier grades. And I agree with Representative Wheelander when she said all special education people are doing essentially God's work, you know, not something that I want to do. But at the same time, we have a number of children that end up incarcerated with special education needs, and had those special education needs been addressed, would not have ended up incarcerated. And then we exacerbate the problem by not paying for that in Unified School District 1. So I'd like to understand that. And my last question is going to be, we talked a little bit about the State Department of Education and the State Board of Education and all of the different groups that are associated with special education and parents and getting people involved. Is there any way to get a listing of all of those so that we can have that capacity of understanding what's out there in the state There's the State Department of Education, the State Board of Education. There's several groups that are studying special education. I don't know how many are studying special education. Apparently, there's a lot. But it seems to me that we have a number of different things going on. I'd like to understand where we are. So, thank you very much, Madam Chair.
Thank you, Senator Austin. And my good co-chair and I are also having some of those individual meetings, so we can put that list together as well. Senator Kissel?
Thank you very much, Madam Chair. Thank you for the fabulous presentation. I don't know if I caught it correctly or not. Did you say that year over year, we've had an increase of 11% of young people being classified as special ed? What was the 11% that you had stated?
The 11% that I mentioned was the increase in the total excess cost asks for districts. The estimate that we have for fiscal year 25 to fully fund excess cost is 11% higher than it was in fiscal year 24.
So, and again, it's probably in your presentation, but I haven't analyzed all the graphs. But how is that? Is that like a hockey stick? Are we like seeing just to me, 11% sounds like a dramatic shift on an annualized basis. And so one of the things that I've talked about privately with the chairs and leadership of the committee, one of the things that's really motivated me to want to be ranking senator on this select committee is that in my district and far more in my largest town, Enfield, there's been a dramatic increase in the number of young people designated as needing special education. And it's being a huge fiscal driver for that community. And so there's this battle in the town. Does this have to do with parents? Does this have to do with people moving into town? Does it have to do with designations by physicians? No, I'm trying to get to the root of why the increase. That's one thing. But also the tremendous fiscal stress it's putting on the municipality. And at the same time, they're looking to me, and if we're constantly shorting them from what their expectation is, it's creating huge stress between the Board of Education and the council. And I'm sure all of my colleagues are going through the same thing. So with this dramatic increase of 11%, are we in a new world here? And because I'm concerned, part of this is the financial aspect, and thank goodness we have Senator Austin on this select committee because as co-chair of appropriations, but we also have all those other ramifications, the quality of education opportunities being afforded. Is it fair? Is it fair across 169 municipalities? And I get all that as well. But I'm trying to get my arms around, are we in a brand new world? And I've seen this in other areas over the years here in the legislature post-pandemic, that the pandemic sort of brought to the fore a lot of things that were sort of beneath the surface, especially mental health issues and things like that. But this seems to me somewhat different than something related to the pandemic. This may even be like an RFK Jr., like what we're eating, what we're giving our kids, like what's in the air, and I don't know. And I think that if we ignore the root causes of what's happening, we're going to be facing like huge financial obligations that we're not going to be able to meet. And the stressors that are happening in our communities are only going to get exacerbated. So I'm trying to, like, if I can go to my towns and say, this is what's going on, this is what we're doing. And even if it's a long-term addressing of their financial aspects so that we have quality of education, at least we're living in a world that has predictability. Right now, I feel like I'm just in a dark room and I have no idea what I'm bumping into. So again, is this 11%? Is this something, did we create a record with that 11%? Have we ever had 11% in a single year? And does that look like it's going to continue on that rate?
So I put the chart back up that has the 11% reference. In fiscal year 24, costs rose by 25% from fiscal year 23. And that was larger than I think anybody had anticipated at the time. And there's a lot of questions about why special ed costs are increasing so much right now. I do have a slide in here that has the identification over time. And that has been rising over time. I don't have a breakdown for town by town. So it could be district for towns, but overall in the state, it's risen a little bit over 4 percentage points in a 10-year span. So it is increasing overall in the state and overall across the country, like RepCon read those statistics as well.
Well, I appreciate that. 11 is better than 25, that's for sure. I guess I just want to take a step back and maybe like throw out to our leadership, and I appreciate Chairman Khan indicating that we're going to have another presentation, God bless you, on Wednesday. I guess I'm looking at it sort of naively. I'm looking at it like designating a student as special education and that's the driver. There may be other more nuanced things, and I'm just wondering if there's any way that we can drill down deep on this, because maybe it's a relatively similar cohort of students, but maybe what their needs are more expensive. I don't know if these third-party providers are jacking up their rates. I don't know if the designation of the students is more high-end versus low-end. You know, someone that has really huge needs and is like, I mean, I've heard stories in my town where someone just flies into the town halfway through the school year and they have $200,000 worth of needs, and the school has to just run with it, and it's not budgeted for. So I think to the extent this committee sort of can start to get its arms around what is driving these costs. And I don't know if it's just the number of special ed students, or if it's the cost of the services, or if it's a distinction between how they're being designated, and if they're more on the lower end of the cost spectrum versus the higher end. I just need to know what world we're living in before I can try to solve any of these issues. And to the extent that you guys are the numbers folks, I would appreciate any guidance that you could offer. Thank you, Madam Chair.
Thank you, Senator Kissel. And I just want to add to that too, because I have heard from a number of superintendents that those third-party provider costs have gone up significantly year to year. So if we can get some kind of comprehensive overview of what those costs look like, maybe for the last 10 years, you know, and get some sense of like perhaps where the increases are coming from. And I think that may be a piece of it. So we can at least look at that. Yes. So thank you for that. And then I have, I'll go down my list. So I have Representative Corpus.
Thank you. I wanted to follow up with what Representative Nuccio was asking about and make sure I understood, if you would, the slide on page 8. So it says earlier in the presentation that there are 87,000 special education children in the state, and of those 44,351 had eligible expenses. So that means that 83,000 students are being funded out of a combination of the educational cost sharing formula and the municipal budgets and whatever federal aid there is. Okay, so the vast majority is being funded through general education. Does it create some kind of, I mean, obviously those dollars are competing for general education and special education. So in our state by state comparison, it would be interesting to see whether our threshold is very high, that 4.5 times compared to other states, because we're getting not even the majority, we're getting, you know, 95% of it out of our general education budget. Thank you.
Thank you. And then Representative Wiellander, I have you next.
Thank you, Madam Chair. Thank you for the information. I just have two quick questions. One is, do you know when the 4.5 times level was set? And is that set by us?
I don't
Kristen?
know. It's been 4.5 for a while. In the mid-90s, it was 5. So at some point it changed.
Okay.
But yes, it's in statute.
Okay, thank you. And do you know, I know that you mentioned that every year the percentage of the tier reimbursement changes. Can you tell me how often those tiers are evaluated, the system, and how the breakdown is, if you can direct me?
Sure. So there are higher reimbursement tiers in statute, right? But those aren't actually used because there's never enough money. So actually in an initial version of the presentation, we had those tiers in and we're like, we should remove those because that's confusing. So the tiers that you saw are what was actually used in 24. So every year when SDE gets the data on the eligible costs for excess cost. They look at how much each town has and then what their rankings are. So they set that, they group the towns in the tiers and then they figure out the exact percentages that they can use, keeping generally within, we're going to keep around 3 percentage points difference between the tiers, figuring out what the reimbursement percentage rates need to be in order to use up all the money. So that's kind of the process. So they do it every year. So the tiers change. The towns can move within tiers if their property and income wealth rankings change, but then their reimbursement rates will also change based on the total pot of eligible expenses for excess costs, right? And that's what makes this tricky. We've been hearing, oh, our towns are saying we're getting reduced excess cost rate. And it's like, well, your percentage rate probably did go down because the eligible expenses went up by 11%, or the uncapped, amount went up by 11%. So towns aren't getting the reimbursement rate that they got last year. They're going to get something lower because overall expenses grew.
Okay. So that's a lot of moving parts for municipalities to try and boards of ed to try to manage. So there's a chance that not only can we, not a chance, what we are doing is that Board of Ed is not able to anticipate or predict what the cost is. And at the same time, they're not able to predict what tier of reimbursement they might be in. There could be a change in that. And then,
Yeah,
Okay.
there doesn't tend to be much movement among the tiers, but it's the reimbursement rate percentage that really matters, right?
mhm.
And that's what floats depending on the universe of eligible expenses for excess cost.
Okay. All right. Thank you for that information. I appreciate it. Thank you, Madam Chair.
And just, I wanted to reiterate, and within those tiers, there's no accounting for how much towns spend. There's no part of the formula that accounts for towns that have historically spent more on special education, except the percentage they're getting back on the amount they spent.
Right. The tier isn't related to what your average cost per pupil is, which determines your threshold for eligible expenses.
Okay, Representative Zupkis.
Thank you. That was kind of my question. So these tiers are created by the State Department of Education, correct? Or who's
Yeah,
in
they're-
what tier?
Yeah, they group you in the tiers, but the adjusted equalized net grant list is something used for several other grants as well.
Right. I would like if you would please send a list of what districts and towns are in what tier. And to Representative Wielander's point, schools to budget, forget it. I don't know how they would ever be able to do that. So I think that's something we need to look at kind of as a committee. And then to Senator Kissel's point, I think, we tend to put Band-Aids on a lot of things instead of really getting down to the core of the problem. And as I looked at that graph, where, students, it increased a very small percentage, but cost went through the roof and it doesn't go together. It makes no sense. So I would like the information. I think maybe it was asked even before as to what does that consist of? And I understand transportation and rural towns and kind of the answer that we get all the time, but really, why is if 3 students, you get 3 more students that qualify in your district, why does it go up astronomically?
So last year during the state agency budget presentations by SDE, that was one of the questions that they had. It's like, okay, so there was a 25% jump in the uncapped entitlements for excess cost, and why is that? And at that time, they looked into it and they're like, it seems to be a combination of factors. It's not necessarily more students are qualifying, or not that many more are qualifying for excess cost. It's just their services got so expensive. And it wasn't clear at that point if it was that the basket of services they were requiring was more intensive or just costs had increased due to inflation. We can certainly follow up with them and ask them more, and you can also have conversations with them. But I think, that's the $2 billion question, right? Is why are costs going up so much?
So they really did not answer the question.
I think that it's hard with the data that they have. It's the type of data that they collect for excess cost doesn't necessarily lend itself well to figuring out a clear answer to the question. And when it's, 4,000 students, if you're going to collect additional information, it needs to be pretty granular and you have to have a lot of buy-in from the district. So I don't know that they thought that was feasible at that time, but maybe they have done more deep digging into it since then.
Well, because I would say this is our purview for this, and we're at the point where we need all the data, not like hundreds of pages of things that they had to collect over the last couple of years. But I mean, we can't measure it if we can't. And we can't manage it if we can't measure it. So I do believe there is a lot of data that needs to be had. I will say the Ed site and all are very cumbersome to go in and try to find these things. So I would think the State Department of Education does have a lot of data. And I think we just have to get it from them or whatever they have. Thank you.
Thank you. And Representative Pools, our Vice Chair.
Hi. I'm interested in a breakdown, and I don't know if this exists, a breakdown of the submitted eligible costs. We've heard a lot of conversation today about expensive outplacements, and I wonder if the data are available for the outplacements versus districts that submit for excess costs for in-district programs that they have created, have funded, running to within their districts. And what's that breakdown and exactly the numbers on that? So if you have it on hand, great. But if not, if you can get that, that would be. Thank you.
Great, thank you. Yes. Representative Johnson.
Thank you, Madam Chair, and thank you so much for your presentation. Going to this excess cost reimbursement tiers, I agree that we should take a look and see the towns and what categories they're in. I'm wondering one thing there's 54 towns in the category with the least amount of wealth, and so I'm wondering are those towns also towns? They're considered in the education cost sharing grant, for example, or they're considered where where they subsidize the state in other areas, say, for example, with non-profit organizations that don't pay any or do not pay any tax at all, or this town gets a payment in lieu of taxes. Is that how you determine the wealth, the least wealth?
The property and income factors used in ECS and excess cost are different but similar. So the towns that, have a low equalized net grand list per capita in ECS are probably also going to be in, getting the highest percentage reimbursement for excess cost because they'll be in the low wealth for the adjusted equalized net grand list per capita that's used for excess cost. So the factors are different, but similar enough that you'll see a lot of correlation between them.
And to just follow up on that thought, so for example, the Connecticut housing authorities do not provide any payment in lieu of taxes to the towns. So in the districts where you have the numbers of Connecticut-based housing authorities, is there a way to analyze how many students that come from the low-income population in those areas where there's no property tax being paid at all, to be able to see if they are in the 54 towns that are listed as the least wealthy?
So for both ECS and excess cost, it's looking at net grand list. So if a property isn't taxable, it's not included on the grand list. So the towns that have large shares of non-taxable property aren't seeing the value for those non-taxable properties in their net grand list. So they're already you're going to see a lower net grand list than you would if they'd consider those properties taxable. So it's kind of already adjusting for having a lot of non-taxable property within those metrics.
I see. So according to documents I received from your office before, the town of Wyndham, for example, total value of the town, 40% is not taxable. So it's it is not considered in this analysis. And so then the other question that I have is in terms of the grants, do you have them, if you do a listing of the towns, will you also give us a list of the, what were, and I think this has already been asked, but the types of services that are provided, that go past the 4.5%, or so if we, is there a way for us to be able to look at those services that are provided to the students that go into the excess cost?
Yes, we will look into that question, which I think was partially asked before. I mean, I think for many towns, right, that the excess cost students are generally students who are getting outplaced, but that's not always the case. But it's just because the threshold for getting an excess cost reimbursement is so high that for most students, it means that they're getting an outplacement in some way, shape, or form.
And
But we'll
does
look
the
into that.
state, oh, I'm sorry. Does the state make the decision about where the excess cost will come in, or is that just a straight, submission to the Department of Education, and they just go by whatever is submitted? Or do they make a judgment as to whether the amounts that they will pay for and keep them within the 4.5%? Or how do they make that determination as to what's ineligible to cost in terms of when they get that information from the town?
So the districts submit their expenses for students that they think are going to meet the 4.5 times threshold. So if a district thinks that, oh, our expenses for this kid are going to meet the threshold for the year, then we're going to submit information on their eligible costs. So then SDE takes that total bucket of costs and says, okay, your town is responsible for 4.5 times your NSEP. And then excess costs will pick up the rest to the extent that it's able because the appropriation is capped. So that is generally how it works. I think that there are a few technicalities like, oh, it has to be like an approved private provider. We're not going to pay for an unapproved provider, maybe for excess costs. So there are a couple of tricky things, but I don't think that SDE like verifies the costs that are submitted. I think, the districts submit their costs with whatever is required from SDE. But I don't think that SDE goes through and judges like, is this the right service for this kid? I think it's just, here are their costs.
And then one final, I know that I try to describe to our finance committees and our Board of Ed and so on, the systems, which are quite complex. And the thing that Senator Kessel was speaking of is the fact that many times the budget isn't enough when someone moves into the town that needs a lot of services. Some need to be put in, say, institution for a time. That kind of thing will cost, and that ends up being placed on the local, Board of Ed's budget, but you don't know about it till the following year. And these are things that really create a lot of concern, especially in towns like mine. We vote on the budgets every year. So if you see an increase in education, people will vote it down. So there are real problems with making sure that we provide the services. So I'm just wondering, is there a way of notifying towns during that period of time where the new student comes in and needs all these extra services?
I'm not sure exactly what you mean. I think that, the district, if somebody comes in who has a high level of need for special ed services, they have to adhere to whatever the student needs.
Yeah.
And I'm not sure to what extent that information or how that information filters from the people in special ed who work for the district to the district finance office to the town finance office. I'm not sure about how that communication works.
Okay, that I'll do that. That's probably a little bit outside the scope. One final question is the operating income wealth. How do you have a way of determining what operating income wealth is? How do you figure that out? For example, we had issues this year where revals were done in different towns. The revals were done, And then the values of properties have gone up in towns. And then money was removed from the education cost sharing grant in the towns where they showed an increase in the values of the property. At what point in time, is that part of the income, operating income wealth?
So the ECS formula looks at median household income, and the adjusted equalized net grand list, as it's used in excess cost, looks at, I think it's per capita income. So they have two different income metrics. But both of the metrics, both the excess cost one and the ECS metric for property wealth, involve a process of adjusting the net grand list even in years when there aren't revals based on changes in property value. We actually did a really thorough analysis on the equalization aspect of it, and we had some counterintuitive findings, but basically, there are adjustments being made every year for changes in property value, even when there's not a revaluation. So the formulas, both of them, ECS and excess cost, already take that into account. It's not just we've had a revaluation and, our values change for ECS or excess cost so much. It's like, no, they're actually changing every year because it's part of the equalized term for both of those grants.
Great. You said you did an analysis. Could we have a copy of that analysis so we can see where those fluctuations occur? And of course, this was something that was a great deal of concern by people in Board of Ed, Board of Finance, and the council, because it had the loss of $500,000 in my district was based on, everybody said the reval, but to lose it mid-cycle is a real detriment to the towns. And so I'd like to see what law you have there that actually does that sort of change. Thank you so much. Appreciate all your help. Thank you, Madam Chair.
Thank you. And I see on Zoom there's a question for Senator Bertha.
Thank you, Madam Chair. Thank you to OLR and OFA for their presentations. I'd like to piggyback on what Representative Nuccio and Senator Kissel spoke to earlier with respect to some of the data that may or may not have been collected from other states. I think it would be good for us to be able to know, maybe for some benchmarking, what percentage of public school children in other states are designated or classified as special education. We know what the numbers are here in Connecticut. We can do the math and determine by those numbers what the cost is per pupil to educate each year. And that's what a large part of this conversation this afternoon the discussion has turned to. I also think it would be helpful for us to understand, since Senator Kissel had a large concern about the increase in the cost, or particularly over the last couple of years, which I think is probably somewhat inflationary, in addition to maybe some other factors that we don't know yet. But I'd like to know if other states have seen similar increases, a percentage of increases in delivering their special education cost. And then lastly, I think it would be good for this committee to know, as we are trying to figure out how we can address the cost of special education and maybe contain some of the cost, to know, because I know, for example, the state of Massachusetts has a new rate schedule that they adopted, I believe, last year for the cost of special education services. And I'd be curious, again, I realize this is a lot of things I've asked for, and maybe it's not an OFA thing, or maybe it's an OLR, maybe it's a combination, but I'd like to know what states are using rate sheets or a charge sheet for the delivery of special ed costs, because I find it disturbing that you can have a school district agree to buy services for some aspect of the special ed delivery, the delivery of special ed services, excuse me, and then that cost can just all of a sudden change because maybe there's not a contract, what have you. I think this could be a good first step for us in containing some of this cost, is having a rate schedule that providers of services would ultimately adhere to. So I know that's a lot. Thank you, Madam Chair. I don't have any direct question necessarily for the good folks at OFA, but thank you for a moment to speak.
Thank you, Senator. And we will, Representative Khan and I will be working with OLR and OFA to get all of these questions on information
Thank you.
packets available. So we'll work together to make sure the committee gets that.
Thank you,
Are there
Madam.
any other questions? Did I miss? Yes, Representative.
Yeah, I was just gonna kind of say that start that I know there was a lot of like follow-ups and so I do want to give you guys some time to get us some of those follow-ups, and then we'll put all of it together in one and distribute it to the committee so that it all comes as a packet. And you know, if folks want to follow up, they can follow up individually with folks, but we will allow you guys some time because I know we gave you a lot of homework, but we really appreciate the information that you have presented us today. I know that we also got digital copies of the presentations. If anyone didn't receive, I can make sure that that is received on for all members as well. But thank you so much.
Thank you very much. So before we adjourn, let me just mention the date and time of our next meeting is Wednesday at 11 a.m. We're going to hear from the task force on their report. I also mentioned at the beginning of the committee meeting that we have started organizing our public listening sessions. We would really like to meet the community where they are. So we're planning a listening session in Southern Connecticut, planning a listening session in Eastern Connecticut, the Northwest corner, and then one will be in Hartford as well. And the one that's in Hartford will have Zoom option for anybody who's not able to sort of come in person to be able to testify by Zoom. But we'd like to keep those opportunities open for members of the community to be able to access if they wanted to come physically in Southern, Eastern, in the Northwest corner to be able to attend those sessions. So we will have those dates out. It'll be in the first 2 weeks of February. We only have one confirmed so far. So on Wednesday, we'll have the dates for you for all of the sessions that are confirmed. And there's a question, Senator.
Yeah, quick question, Madam Chair. Will the members be able to access those remote hearings via Zoom?
Yes, we're doing the best we can with that. We're working with the community colleges, and I believe that most of them will have that technology, but we have asked. And so we're for members who cannot drive across the state for whichever, we're trying to keep a link open as well. Yes. Another question?
Thank you, Madam Chair. I'd like to just sort of put a plug in for having a listening session in Western Connecticut because we're leaving a very, very, very large chunk out when we skip Danbury, Newtown, Bethel, Ridgefield, all of these towns that are not in the northwest corner. Thank you.
Yes, thank you for that.
Appreciate it. I know it's.
Yes, no, that's good. We were trying to assess what locations without overwhelming the committee. So we'll certainly go back and talk about adding that as well. Okay. All right, great. Thank you, everyone. Thank you so much to OFA and OLR and for everyone. And the meeting is adjourned.